Hello, I'm constitutional attorney Catherine Henry. Welcome to this week's Constitution segment recap. Today we are recapping episode 38, Republican state reps support overreaching hunting regulations. Now, keep in mind, this is just a Constitution segment recap, so if you want to hear the full discussion or get into a lot of detail on each of the cases or the constitutional provisions or the laws cited, then please make sure to watch or listen to our full episode that aired on Tuesday at noon, and you'll get a lot more information. Also, please keep in mind that since I'm trying to keep these Constitution segment recaps to only 10 minutes or less, I'm not going to go into detail about where I'm getting all of my statements here. If you want to see all of the state laws, all of the US or state constitutional provisions, or even cases as I refer to them, all of those citations are going to be in the slideshow presentation that you can access by clicking on the link in the description of today's segment. So please make sure to follow along with that or just check it out later. I'm not expecting you to take my word for it when I say all these things about the Constitution and where our rights come from and what government can and cannot do. You can, and I want you to, double check me and look at every single one of those citations, but I just don't have the time to go over those again in detail today. So with that being said, hang on because we are going to get started. All right, so the full episode, we talked about conservative, supposedly conservative state reps increasing hunting rules and regulations and violating the Constitution in the process. Yes, 3 Michigan supposedly conservative legislators were touting House Bill 6354 as eliminating penalties for DNR violations. Now, I'm going to pause right there on that note because if you are not from Michigan, I guarantee you this is still going to be something you are going to want to listen to or watch, whatever the situation might be there. And here is why, because all of the background, all the reasons why the government can't do what they're trying to do here would be the same in every single state. So I'm going to give you some Michigan examples and things that specifically pertain to this bill that's in Michigan right now, introduced on August 17th in the Michigan legislature. But if you are not in Michigan, I guarantee you this is information that you still want to know and will still be pertinent to you. So with that in mind, we're going to back up again. This is 3 supposedly conservative Michigan legislators that have introduced House Bill 6354 and have the title on it, the official title on the Michigan legislature website, as a bill that is supposedly eliminating penalties for DNR violations. Yet with this bill, the law will still have criminal and civil penalties. It allows for more reporting rules and regulations. It requires inconsistent and impractical reporting methods, and it codifies DNR orders as laws. We've heard that problem before. If you have any information or concerns about this that you want to seek more discussion on, please make sure to contact these Michigan state reps directly. At least one of them is running for Congress currently, but those state reps are, not Congress. She's running for state Senate. Either way, still a bad deal for the people of Michigan if she can't figure out the Constitution or the laws in the state of Michigan. Those state reps are Hoytenga, Harris, and Filler. Again, this is House Bill 6354, and the state law involved is MCL 324.40118. And again, you can find all of that and pause it where you need to if you take a look at that slideshow. So under the Wildlife Conservation Order 3.103, Subdivision 3, which you can find here, the hunters are required to report their kill to the DNR via the website, a specific website, or the DNR app. In fact, deer harvesting must happen, that you must report your deer harvesting or the kill within 72 hours via this very detailed process that, by the way, is not even written into the order itself. I have some screenshots for you so you can actually take a look at this and see why some of this is so insane, and the level of detail that they are requiring in this reporting is really not okay. But in order to understand why it's not okay, in order to understand what's really wrong in this whole situation, we need to first recognize some basics. Number one, that we get our rights from God, not the government. Again, all the citations are going to be in the slideshow, so make sure to check it out that way. All of our rights are meant to be, are designed to be exercised undiminished, unrestrained, unabridged, uninfringed, unviolated, undenied, undeprived, and unabused, and usurped. Make sure to check out that slideshow for the details. We, the people, created our constitutions and our very form of government to secure the blessings of liberty given to us by God. In other words, government's main purpose and responsibility is to protect our God-given liberties so that in my exercise of my rights, I'm not impeding upon your exercise of your rights. But government has no rights. And you can see the 9th and 10th Amendments for more details. And more importantly, government only has those powers which we specifically delegate to it. This means government cannot act unless there is a specific power granted by the Constitution. Anything that the government does, it is prohibited from doing anything that violates the U.S. or state constitutions. And in fact, every government official is sworn to the oath of office. Some rights we need to consider are equal protection, due process, right to privacy from government, in some instances, criminal trial rights, and of course, our unenumerated rights. But we also need to remember that the United States Constitution is the supreme law of the land. That literally means that no federal law, no state law, state constitutional provision, court order, or any other government action can be repugnant to the Constitution. If it is, it's void on its face. And remember, all government officials are required to take that constitutional oath of office. So when it gets down to the brass tacks of what we're talking about today, it should not be a crime or a civil infraction to fail to report a deer harvest on an app within 72 hours. Well, we don't need our permission from the government to grow food, hunt, or fish to provide for our families. These are God-given liberties, not government created. As far as reporting a deer harvest, let alone within 72 hours, what does that have to do with the government protecting our liberties? Nothing. Nowhere in the Constitution is government given the right to make such a requirement, and it's void of common sense to require the use of the internet while hunting. And government technology, of course, is bound to fail. So we are not allowed to stop, they are not allowed to stop serving the public, instead only using technology. Hunting regulations must not be so complex. In fact, not only are hunters being denied realistic notice and opportunity to be heard on the creation of these massive regulations, but the sheer volume of them makes it impossible to completely read, understand, and follow. I guarantee you those 3 state reps have not done that, because there are hundreds of state laws on hunting, hundreds, if not thousands, of subsections in those laws, and hundreds of pages of these DNR regulations each season. But hunting violations must not be crimes with possible lifetime hunting bans. Why? Well, we don't need permission from the government to grow food, hunt, or fish to feed our families. Again, we talked about that. And practically speaking, how is banning someone from hunting for life helping society or protecting anyone's rights? Well, DNR reporting must be easily accessible and consistent. What do I mean by that? Well, inconsistent reporting requirements exist. Yeah, sometimes you have to report a kill as instructed by the department, whatever that means. But sometimes you have to report by calling the department at a designated telephone number, but yet other times you have to report a kill as instructed in a training session. And well, they're inaccessible to understand what these are, because the exact reporting requirements are not even written to the law or even these DNR orders. Again, all it says is report as instructed by the department, as designated by a department phone number, and as instructed in a training session. But yet we have no idea what those specifics are at this point. DNR orders must not be treated by laws, no matter what, though, and the DNR cannot make laws. There's a separation of powers. The U.S., that's implied, but certainly in the Michigan State Constitution, it is expressly written into the state constitution. And the DNR is in the executive branch and does not have those legislative powers. But all DNR orders are unconstitutional, not only because of that separation of powers, but because of an issue of due process. In fact, they didn't go through the proper due process. In the Michigan State Constitution, you can see that legislation must be enacted by a bill. You cannot have amendments to current state laws without fully reprinting the text of that. And if we're treating all of these DNR orders as laws, then any subsequent order or amendment thereto would have to reprint the entire thing, showing what's changing from year to year, and they don't do that. You must also wait 90 days for an effective date unless the legislature has passed this change by a supermajority, which they don't, because they don't vote on these DNR orders at all. The style of a law in the state of Michigan says that the people of the state of Michigan enact. That doesn't happen in these DNR orders. And no law shall embrace more than one subject, yet these orders are literally hundreds of pages long and cover quite a few things. But of course, there's even property deprivation and jail time, which you can get as a violation of your due process rights. But all DNR orders are unconstitutional as well, because there is that right to equal protection, which does not exist. And you can watch the full video to hear more details on that. It is clearly a violation of our right against unreasonable searches and seizures. It violates our very unenumerated rights that are talked about in the U.S. and state constitutions. And it ignores that political power is inherent in the people. But where have we heard about this before? Well, you have had definitely your fair share of these orders from the executive branch that are being treated as laws in whatever state you're in some capacity or another. But in the state of Michigan, it is the 1945 EPGA, the 1976 EMA, and the 1976 Public Health Code, where we have heard these talked about, debated about, and certainly litigated on, all the way up to the Michigan Supreme Court. In fact, there was the case with the legislature suing the governor, then Midwest Health suing the governor, and Iron Pig suing MDHHS, the state health department. I've done videos on all of those cases, and you can find more details on those by searching for those. And you can go right to our website or YouTube channel to find out more. But the in-re certified questions one, that's where the Midwest Health versus the governor case was listed there. That's a case from 2020, one that I was blessed to have the opportunity to argue in front of the Michigan Supreme Court. Clearly said that, among other things, I'll just read to you the most highlighted and important provision here, that the legislature's power is only to make laws, not legislators. So the legislature cannot write a free pass to the DNR to issue these orders every season and then have those orders be treated as laws, because they are not in the business of making legislators. They are in the business of making the actual laws themselves. But don't fear if you're in another state, because Field versus Clark is a 1892 case in the U.S. Supreme Court. And if you listen to the words of Justice Harlan, who wrote the opinion of the court, you will hear him talk about the true distinction in this topic is between the delegation of the power to make the law, which necessarily involves a discretion as to what it shall be, and conferring authority or discretion as to its execution to be exercised under the law. And what he's saying is that the first cannot be done. So in other words, what is being said there? Well, to say it a little bit more clearly or succinctly, look at the words of Justice Scalia in the 1989 case in the U.S. Supreme Court, that there is no acceptable delegation of legislative power. And the power of the legislative is derived from the people by a positive voluntary grant, and it can be no other than what that positive grant conveyed. In other words, the legislature can only make laws and not make legislators. In fact, as he's quoting John Locke there, he says the legislative can have no power to transfer their authority of making laws and place it on another, in another hands. So I have some slides in here that I want you to check out. We're already over our time, and I'm not sure how I'm going to quite get this all into the 10 minutes, but foot soldier of the Constitution is the question, because this is the image and the wording that Michelle Hoitenga as state rep has chosen to advertise herself as. Yes, she calls herself the foot soldier of the Constitution. In fact, she's talking about your rights to use firearms and shows herself in hunting gear shall not be infringed. And her quotes and her advertisements I've put right in this slideshow so you can take a look at it. But it's amusing to me that she's also showed pictures or put pictures of herself on her social media where she's holding the Constitution of the United States. And in fact, in her bid for state Senate, she says, elect Michelle Hoitenga, pro-life, pro-gun, pro-parent, and pro-liberty. Yes, running for state Senate. But she is one of those conservatives who also believes in collective rights, which we've done videos on before, in fact, in this season. So check out those earlier episodes. She believes in collective rights, mask mandates, and government overreach. In fact, look at the pictures I've put in this slideshow of her posting on social media while on the campaign trail, and where she's talking about that health in a collective sense. And that is all why Wednesday's Way to Get Involved challenge was to contact state representatives Hoitenga, Harris, and Filler to fix House Bill 6354 and, in fact, fix the entirety of MCL 324.40118, because it should not be a crime or a civil infraction to fail to report a deer harvest on the DNR app or website while you're out hunting and probably don't have internet within 72 hours of that kill. And hunting regulations must not be so complex in the first place. Hunting violations must not be crimes with possible lifetime hunting bans. DNR reporting must be easily accessible and consistent. And of course, DNR orders must not be treated like laws. They constitutionally cannot be treated like laws. If you would like more information, despite this being broken up into 2 segments that are almost spanning the full 10 minutes each, make sure to watch the full episode from this Tuesday, like I mentioned. Make sure to check out our post wording and links and whatnot for our Wednesday Way to Get Involved challenge that came out yesterday. And of course, pay attention tomorrow for our Friday freedom fighting tools that we will have available for you. Again, my name is Catherine Henry. I'm a constitutional attorney, and I am bringing to you everything I can each week on a volunteer pro bono basis to make sure that we can work together to restore our freedom. If you like the work that I'm doing, please make sure to hit that like button and share button. Please make sure to subscribe and get notifications. Share all of this information that we're doing with your friends, family, coworkers, and neighbors. And please consider donating on the Shop Donate tab of our website, restorefreedomkh.com, because all of this cannot continue to be done without the help of people like you to keep this going, because literally all of the hours and hours and hours of work that I do on this is all on a volunteer basis, and it takes the donations from you to keep it all running. So again, I'm constitutional attorney Catherine Henry. Thank you for joining us for this week's Constitution segment recap. We look forward to seeing you join us for next week's full episode, airing live at noon on Tuesday on YouTube, Facebook, Twitter, Twitch, LinkedIn, DLive, and Rumble. If you want to make sure to have the ability to comment live and engage with us interactively, make sure to be able to join us on YouTube, Twitch, or Facebook, because we will be able to see your comments live in the discussion then. Otherwise, thank you so much for joining us today, and I hope you have an absolutely wonderful rest of your week.